Dr. Lewis, if you want to go ahead and take back over and introduce oral argument 3.
Okay, this is Dr. Ron Lewis. Our next order of business is to discuss the case of Dr. Brian Flores, and this is an oral argument following a remand. And I'll turn this over to Judge Wong.
Thank you, Dr. Lewis. So, Madam Court Reporter, if we could go ahead and go on the record. We are on the record before the Medical Board of California, Department of Consumer Affairs, State of California, in the matter of the petition for early termination of probation of Byron Flores, MD. It's MBC number 800-2017-038435. It's OAH number 2020-040351. My name's Corin Wong. I'm an administrative law judge with the Office of Administrative Hearings. This is the date set for oral argument and the notice of hearing for oral argument in light of Governor Newsom's Executive Order N-29-20 dated March 17th, 2020. Oral argument is being held as a WebEx event with, looks like I have the court reporter, myself, and Deputy Attorney General Wagner appearing by video, and I have, I see Mr. Garcia is also by video, and Dr. Flores I have by audio only, and then the panel members and the public are by audio as well. First, to establish quorum for the record, and since the panel members do not have video, I ask that each panel member answer audibly after I call his or her name. Dr. Lewis.
Present, Judge.
Dr. Hawkins.
Here.
Ms. Lubiano.
Here.
Mr. Warmoth.
Here.
Mr. Watkins.
Yeah.
And Dr. Yip.
Here.
And let the record reflect that a quorum is present. Next, if I could have the attorneys state and spell their names for the record, starting with the Deputy Attorney General.
Deputy Attorney General Rebecca Wagner, R-E-B-E-C-C-A, Wagner, W-A-G-N-E-R.
Okay, Mr. Garcia, if you would unmute yourself and state and spell your name for the record, please.
Yes. Good afternoon, Your Honor. Albert Garcia, A-L-B-E-R-T-G-A-R-C-I-A, attorney for the petitioner, Dr. Flores.
Okay, thank you. Let's see. I got that going. Okay. So the board in this matter has issued an order fixing date for written and oral argument after Superior Court remand, and has decided to determine the matter itself. The board's order expressly asks the parties to address the following issues. One, the actual told period of Dr. Flores's probation. Two, Dr. Flores's anticipated probation termination date. And three, whether the board's decision should be modified based on a change, if any, to Dr. Flores's anticipated probation termination date. The following process and time limitations will apply. Mr. Garcia will have 15 minutes to make an opening argument, followed by Ms. Wagner having 15 minutes for a response. And then Mr. Garcia will have 5 minutes for a closing argument, and Ms. Wagner will for her closing argument. These time limits will be strictly enforced. And the argument should be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. I or a panel member may ask a party to support his or her argument on a specific matter with a specific reference to the record. At the end of oral arguments by counsel, I will offer Dr. Flores an opportunity to address the panel regarding penalty. If he elects to do so, I will place him under oath and he will have no more than 5 minutes to address the panel. After oral argument, the board will go into closed session to deliberate. So the parties will not receive a decision today, but will be receiving a decision later in the mail. Oral arguments are being recorded stenographically by a court reporter who is at a different location than the speakers. So it is important that everyone identify himself or herself each time before speaking and speak slowly and clearly. We ask that you mute your microphone when not speaking. And then of course, just remember to unmute it before speaking. And also the rustling of papers does get picked up on the microphone when they're live. So please keep that to a minimum. Again, I want to remind the parties that all arguments must be based on the existing record and no new evidence will be heard. Additionally, the board has had the benefit of reading your briefs. So with that, Mr. Garcia, you may begin.
Thank you very much, Your Honor. Good afternoon, Your Honor. Good afternoon, Dr. Lewis and other members of the panel. As a preliminary matter, Your Honor, I have a question for you. I did file a document entitled Petitioner's Objections to the AG's Written Argument After Remand. It was submitted to the medical board on May 5th with a request that a copy be forwarded to you and also that copies be forwarded to members of the panel. So I want to inquire at this time whether you received that particular document.
I did not.
Your Honor, we do have an objection. I'm going to be very brief about it. I'm probably going to count toward my argument here, so I'm going to be very brief. We did file a written objection, and basically it says the petitioner, Dr. Flores, objects and moves to strike the declaration of Verdine Richardson attached as Exhibit A to the AG's written argument, and any references thereto. And it's based on several matters. The Verdine Declaration and references thereto are beyond the scope of the proceeding and violate, 1, the board's express orders limiting argument to the record, and 2, California Code of Regulations, Section 1364.30. The order fixing date for written and oral argument issued by the board on March 19th states, quote, written and oral arguments shall be limited to the evidence contained in the record and shall comply with Code of Regulations Section 1364.30. The notice of hearing for oral argument issued by the board on April 10th likewise states, quote, arguments must be based on the existing record and no new evidence will be heard. And then the board directs the party's attention to, once again, California Code of Regulations, Section 1364.30. That regulation states, quote, the argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may not ask questions that would elicit new evidence. Our position, Your Honor, is that by citing to and relying on the matters set forth in the Verdine Declaration, the board has gone beyond the record, beyond the duly admitted evidence in this case. And so that declaration is in violation of the board's own orders and, of course, the California regulation that I've cited. For that reason, it's a proper argument to which the petitioner objects and moves to strike under the regulation that we've already cited. Petitioner respectfully requests that his objection be sustained and that the Verdine Declaration and all references thereto be stricken from the record. If the panel wishes to hear additional evidence on the tolling issue, it should remand this matter to the Office of Administrative Hearings for an evidentiary hearing under Government Code Section 11513 with its attendant hearing rights, including Dr. Flores' right to cross-examination. All right, that's our objection, and we'll leave it to you, Your Honor, to rule on it subsequently. But at this point, I'll get into the substance of the argument itself. In its judgment, the Superior Court, when granting the petition for writ of mandate, stated, quote, respondent board has not cited any evidence demonstrating that tolling was placed in issue or otherwise part of the fact finding that was before the ALJ at the administrative hearing. The Superior Court then went on to expressly find that, quote, petitioner did not waive the right to contest calculations concerning whether his probation period was told during the time he was undergoing the board-ordered educational program, that's the PACE program. I'm going to repeat that. Whether the probation period was told during the time the petitioner was undergoing the board-ordered educational program. That is the pivotal question that informs the answers to the board's 3 inquiries in this proceeding, and Your Honor has already outlined those. Those questions being, number 1, the actual told period of probation. Number 2, the anticipated probation termination date. And number 3, whether the board's decision should be modified based on a change of any to the anticipated probation termination date. Those are the 3 questions that have been posed and posited. Petitioner submits that the answers to those questions, Your Honor, and members of the panel, depend on the answer to the fundamental question posed by the Superior Court, whether the probation period was told at all during the time petitioner was undergoing the board-ordered PACE program. In other words, you don't start calculating, you don't start counting days until you first address and answer that central question. And the answer to that elementary query is found in probation condition number 11. That condition has 2 components that are relevant to this inquiry. First, that condition states, quote, any period of non-practice within California, as defined in this condition, will not apply to the reduction of the probationary term. That's an end quote. But second, that condition also states, quote, for purposes of this condition, condition number 11, non-practice due to a board-ordered suspension or in compliance with a condition of probation shall not be considered a period of non-practice. Now, why was it that Dr. Flores was not practicing medicine from August 28, 2015, the effective date of the decision, and September 12, 2016, the date on which the board determined that he had successfully completed the PACE program? That's the question. The answer is this: he was not practicing during that period of time because he was complying with the condition of his probation, namely that he complete the PACE program as a condition precedent to resuming the practice of medicine. His non-practice, therefore, in quotation marks, non-practice, therefore, to put it in the language of condition 11, was, quote, due to a board-ordered suspension in compliance with a condition of probation, end quote. And as condition 11 states, for purposes of this condition, non-practice due to a board-ordered suspension or in compliance with any other condition of probation shall not be considered a period of non-practice. The problem with complainant's case, and by the way, I have the utmost respect for Ms. Wagner, but the problem with her client's case is that the complainant fails to address the fundamental issue posed by the Superior Court, whether the probation period was told at all during the time petitioner was undergoing the board-ordered PACE program. Instead of answering that question, instead of addressing that question, the complainant puts the cart before the horse and simply starts counting days. But you don't get there. You don't get to that point until you first address and answer the pivotal question of whether there was any tolling at all under the express language of condition number 11. I think the record's clear, Your Honor and members of the panel. The reason Dr. Flores was not practicing medicine during the period of time from the time of the effective date of the decision until he was cleared to practice by PACE, the reason he wasn't practicing was because he was complying with a condition of his probation. It was a board-ordered suspension. And by definition, under condition 11, that does not constitute non-practice for purposes of tolling the probationary period. There has been no tolling of the probationary period in this case, none whatsoever under the express language of condition number 11. So for that reason, Your Honor, we urge the panel members to look at that condition. It has, obviously, that language has some effect. It wouldn't be there as just mere surplusage. So when the board says non-practice due to a to a board-ordered suspension or in compliance with the condition of probation, that must have some meaning. You can't just ignore that. And I think that's what the complainant has done in this case, not address that particular issue. That language has to be given effect. And the effect to be given to it is the reasonable and rational one, is that Dr. Flores wasn't practicing during that time because he was ordered not to practice. And by definition, that does not constitute non-practice, in quotation marks, for purposes of tolling the probationary term. I'll reserve any time that I still have left for a reply.
Hey, Ms. Wagner, your response, and if you would address Mr. Garcia's objection within your response, please.
Yes, thank you. So the issue is, and I think that Mr. Flores might be technically correct about the actual declaration from Verdina Richardson based on the board's order, the way the board ordered it. However, the Sacramento Superior Court remanded this case to the board to address the issues of the tolling period and the anticipated probation termination date. And the only way to do that is to rely on the board's own records regarding the probation status, which we attempted to advise the board about through the declaration of Verdina Richardson to explain the exact tolling periods in the board's record. If you discarded Verdina Richardson's affidavit, then the issue would be the evidence before the board as it is, which would give Dr. Flores no tolling credits because the probation report that was entered into evidence during the hearing said he had a tolling period of 495 days. And that's the evidence that the ALJ found in the proposed decision. We later figured out while writing the writ that that is inaccurate, that we did not give him enough of the days of his tolling period. And he, in fact, was to have only 369 days of tolling. So the declaration is assisting the board in reviewing its own records to determine this issue, which was sent to the board on remand from the Superior Court of Sacramento. So there is essentially more than one way the board can establish about its, to establish the evidence about its own record. The board, it sounds like maybe this is what Mr. Garcia would prefer, could send the case back to the original ALJ. They could take additional evidence and establish the tolling period and the issues. But it doesn't, it would just waste time for Dr. Flores in this issue to be heard, which is the record that the ALJ heard and at least mentioned in his proposal had the incorrect tolling period of 495 days. And since then, as was described and in Verdina Richardson's declaration, explained the exact dates. If we relied only on the record, then all we know is that we do have in the record that Dr. Flores testified that he began work, I believe, in October of 2016, October 3rd or something. So we know that that period of time can be credited towards him because the 495 days the board had told is less those months after he started work. So for October, November, December, those months will be added and are not appropriate for the tolling period. So it's a bit of an unconventional place we're in, but that's the issues. But the board can't decide the issues on remand without considering its own records, which showed that the tolling period was really for 369 days, and the anticipated probation date is September 21st, 2021. And the real issue then is to reweigh or to consider that, in fact, he did have these additional 3 to 4 months of practice that the ALJ did not know about in making his decision to deny the petition for early termination of probation. It's a bit confusing, but there's no way to, the actual issue on remand is whether to establish the tolling, the probation termination date, and then determine whether that changes the board's decision in the case. Now, Mr. Garcia is arguing a different issue, which is really his issue on the writ, which is he is arguing that those tolling days are wrong, the ones that were already established in the record, because the condition precedent that Dr. Flores didn't have to meet his condition precedent of satisfying, successfully completing the PACE program in this case. So he's kind of mixing up a different issue that he would like to raise, but I think that issue is more an appellate issue at this point because the ALJ has already issued a proposed decision about that. In some, that issue was already brought before the board, and it's not the issue on remand. But nevertheless, Mr. Garcia is arguing that Dr. Flores was suspended and that non-practice time doesn't count. Well, he was not suspended. He just had as a condition precedent to beginning to start work again after not practicing medicine for between 6 and 7 years after his license was revoked for serious and varied causes of discipline. He had not practiced for many years and then was given the chance to be on probation and to have the condition precedent going to PACE, making sure he was up to date on his skills, which there was a lot of concerns that I've outlined in my brief about his performance at PACE, which isn't surprising. He wasn't practicing for more than 6 years. So, of course, it wouldn't make any sense to have a probationary period start when we aren't even able to monitor his practice because he's not allowed to practice until he completes the PACE program. So that doesn't make any sense because the whole point of probation is to ensure that the public will be safe, that we can monitor Dr. Flores during the times he's practicing. Otherwise, he could run off to Tahiti for 4 years and come back and practice for the last year of his probation and say, okay, my probation ran out. So it's non-practice. And in this case, it was non-practice because he hadn't successfully completed PACE and he didn't get credit. The board didn't know that he had started practicing. And so their numbers were off. But once we knew the numbers, then we've calculated it in Verdina Richardson's declaration, which does meet an exception to the hearsay rule, the general hearsay rule, by being a custodian of the records, of the business records and government records of the board, which explains the actual tolling and the probation anticipation date. So I don't know how much time I have left, but the real issue is, does the information that the tolling period was off by these days and instead it was tolled for 369 days, does the fact that he was actually practicing for 4 more months than the board knows change the decision of the board as to whether or not to grant the early termination of probation? And it is our opinion that the proposed decision should not be changed because of all the factors that are important in considering whether to grant an early termination of probation. There was a long period. First of all, his original discipline from May of 2008 was very serious and varied. It was gross negligence in the care of multiple patients, dishonesty and corruption in allowing unlicensed persons to examine children at his clinic and allow them to prescribe medicine to the children using pre-signed prescription forms.
Your Honor, I'm going to object. I mean, there were three issues that were raised here by the board. Three questions, and Your Honor outlined them at the very beginning of this argument. And now we're going back to why the doctor was placed on probation in the first place. Well, that's not the issue. The issue is the three questions that were posed by the panel or the board to be addressed in this proceeding, and this goes beyond those issues.
Ms. Wagner, your response?
Well, you can't, the third issue on remand is whether the board's decision should be modified based on the change in the tolling period, because the original ALJ had a slightly wrong tolling period. And so the decision is, do these extra few months of practice that the board did not know about change the board's opinion? And then you have to weigh the same factors that are to be decided when you're deciding whether or not to grant an early termination of probation. Those are, what was the original discipline about? How many years was he not in practice? And also, while I'm mentioning that, he also had criminal convictions.
Okay, you're going beyond the scope of the objection. So, Mr. Garcia, any response with regard to the objection?
I'll submit it, Your Honor. Thank you.
Okay, so the objection's overruled. The argument thus far will stand. Ms. Wagner, you may continue.
Okay, thank you. And the other part from the 2008 discipline was that he had facilitated false Medi-Cal claims, and these resulted in criminal convictions. So there was a variety of different discipline that was imposed originally, which is one of the factors to consider in this type of case. In addition to the many years he wasn't practicing medicine at all. And then in addition, we had evidence at the hearing regarding his performance at pace, which I've outlined in my brief, and I won't go over that again. And he also had part-time work. He was working part-time once he started on October 3rd. So that period of time when he was working was part-time. And the decision found no clear and convincing evidence of rehabilitation warranting the early termination of probation. So, and the opinion is that, our opinion is that the underlying conduct was so serious and varied, that factor doesn't change based on, just because there was a few more months of part-time work that we now know about. And he was not in practice until more than a year after his reinstatement. That was one of the factors the ALJ relied on. So for more than a year, he wasn't in practice. So that period should be told. And that fact doesn't remain changed, other than the board did give him an extra month in July for that. And the basis was this limited time in practice that was another factor the ALJ listed as a basis. And the only thing that has changed is that these few more months of part-time work were not considered by the ALJ. So the issue is, does this change the board's opinion about whether the early termination of probation should be granted? The anticipated probation date is September 21st, 2021. And we believe that the petition for early termination of probation should be denied, and the tolling period should be set at 369 days. I'll submit it.
Okay, Mr. Garcia, your closing argument.
Your Honor, do I have any additional time from my opening remarks?
You have 5 minutes, a total of 5 minutes to do a closing.
So I can't reserve any of the time that I didn't use up on my opening statement?
No.
All right. The issue here is this. Counsel really mischaracterizes the issue. The issue that was raised, one of the main issues that was raised in the Superior Court, was this very issue of whether condition number 11 the language of that condition regarding non-practice, whether that language means that during the time that Dr. Flores was in the PACE program, that did not constitute non-practice for purposes of totaling the period of probation. That was an issue that was directly before the Superior Court. The Superior Court considered that issue and ruled, again, petitioner did not waive the right to contest calculations concerning whether. Here's the issue, whether. And again, complainant does not address this issue. Whether whether the probationary period was told during the time he was undergoing the board-ordered suspension, the board-ordered educational program. So that's the issue. The Superior Court addressed that issue. That issue was raised in the Superior Court. It was briefed. It was argued. And the Superior Court says, we don't have a determination of whether this period of probation was actually told during the time that Dr. Flores was in the PACE program. And that's why it was remanded. Figure it out. Was it told or not? If it was told, how many days was it told for? But you can't ignore the Superior Court's order here. If you do, and you issue a decision after remand, that decision is going to go back to the Superior Court. He's going to review it, and he's going to decide whether you complied with his order. You have to make that determination. Now, Ms. Wagner says, well, he wasn't suspended. Well, the language of the condition says suspended or you're not practicing because you're suspended or because you're complying with a condition of probation or because you're complying with a condition of probation. What was the condition of probation in this case that kept Dr. Flores from practicing? The condition of probation was do the PACE program, complete the program, complete it satisfactorily as a condition precedent to resuming practice. So during the time you're in PACE, you can't practice. Dr. Flores is complying with that condition. That comes directly within the language of condition number 11 here. That does not constitute non-practice because the reason he was not practicing was because he was complying with the condition of probation. And again, you get into numbers, calculating numbers, but you don't get there until you make that determination on that pivotal question. It's a central question. It's the fundamental question. All the answers to the three questions posed by the board depend on how you resolve that elemental issue. Was there tolling during the time that Dr. Flores was undergoing the PACE program as a condition of probation? That has not been answered. And so now we're going back to, he was a bad doctor, he got probation. Well, that's not what we're here for. We're here to answer these three questions, and the reason we're here is because the Superior Court said, you didn't decide this issue. You didn't determine it. It has to be determined now. And it's not just a matter of starting to count days. You can't start counting the days until you actually address and answer that pivotal question, whether there was any probationary tolling at all during the time that Dr. Flores was doing the PACE program. And I'm not just making that issue up. I'm relying on the language, the express language of condition number 11. It must mean something. That's why it's there. You don't just write provisions of a condition of probation for the fun of it. It has an effect, and it means something. If the non-practice is due to either a suspension or a compliance with a condition of probation, that does not constitute non-practice for purposes of this condition. So there's no tolling. The doctor was complying, and that's the reason he wasn't practicing. And so all the other arguments about calculating and getting it right or getting it wrong, that is completely, you don't get there until you answer the fundamental question, and the complainant has failed to address that question. I didn't hear one comment that had to do with the interpretation of the condition number 11. And that's why we're here on remand. We have to decide what that means and how it applies in this case. Otherwise, we're going to be back here again in a few months if the decision after remand does not address that issue.
Thank you, Mr. Garcia. So, Ms. Wagner, your response?
With all due respect to Mr. Garcia, we simply disagree as to why the issue is here on remand. The judge in Sacramento Superior Court, because of our brief that we had filed in Sacramento, we notified the court that although the proposed decision has, the date tolling period of 495 days, that the board had discovered that that date is inaccurate. And the judge's ruling was, well, I can't reassess the decision as to whether or not early termination of probate. I can't make the factual determination of the correct tolling period based on based on in the writ, that the board has to make that decision. It's a factual issue that we made an error, that was an error in the record. And it's on remand to determine the correct number of tolling dates. That's why it's on remand. Now, counsel is bringing in this other issue that he also would like to argue, that his original tolling period is inaccurate because he's claiming that he didn't have to complete the PACE program, which it clearly states in the probation order. He cannot start practice until he has the condition precedent of successful completion of the PACE program, which makes common sense. We're not just going to let him start practicing medicine after 6 years without practicing medicine. Count that towards his probation when he hasn't even successfully completed PACE and is having a lot of troubles in successfully completing PACE. So he would like it to say that. He would like the board to make that determination. I don't think that's the issue that we're here for. The issue is to set the correct tolling days and to reweigh whether that changes the board's opinion, which is exactly what the remand order says. And the reason why the judge brought that up is because, in fact, the tolling period was incorrect that the ALJ relied on based on the discovery that he had been practicing for a period of time we didn't know about. So I'll submit it to the board on that.
All right. So before I check with Dr. Flores to see whether he wishes to address the panel regarding penalty, I'll go ahead and rule on Mr. Garcia's objection. I'm sustaining his objection to the declaration attached to the Attorney General's written argument, which is the declaration of probation monitor Verdena, Verdena Richardson. So the objection is sustained and the declaration will not be considered. So Dr. Flores, do you wish to address the panel regarding penalty?
Yes, Your Honor.
Okay, before you do, if I could have you raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you will provide in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, so you could put your hand down, and I just ask that you keep in mind that you're limited to no more than 5 minutes. And with that, whenever you're ready.
I am ready, Your Honor. I am ready.
Go ahead.
Good day to everyone in the panel, Your Honor. I just feel privileged that the medical license was reinstated. It's privileged. I do understand that. I'm not here to deny what very wrong things happens in my professional life. I recognize those. I did, I am, and probably I will pay for those mistakes. The reason for which I was working only part-time is not my decision. It's because most of the times, because my current medical board probation status limit my positions available out there. You are not going to believe that even as a volunteer with the state of California, living in these bad days of the virus, even these people say, no, Dr. Flores, thank you. You cannot volunteer with us to help the other sick people in the state. So that and some other things that happens when you are under probation limit my possibilities of working normally. I know, do recognize I did wrong. I take multiple ethical, professional, medical hours of studying. I now recognize, I'm able to recognize the red flags that led me to my mistakes. I'm not denying anything, not before, not now. And probably I have to disclose this for the rest of my life. Anytime I apply for a job, for hospitals privileges, for any place I go, I'm going to go with this baggage. I have to live with that. That I please. It's very difficult for me, for my family to survive in this environment. I hope not so, but the things are going to be a little bit more difficult to everyone. Please just release me for this probation. I know what I did. I know I can do better. I am doing better. Mrs. Richardson, my probation officers, she is in contact with me all the time, and she can back it up what I'm saying. Thank you very much.
Hey, thank you, Doctor. So now I'll turn it over to the panel for any questions. First, Dr. Lewis, do you have any questions?
No, I do not have any questions, Your Honor.
Okay, Dr. Hawkins, any questions?
No, I do not.
Ms. Lubiano, any questions?
No questions from me. Thank you.
Mr. Warmoth, any questions?
No questions.
Dr. Watkins, or excuse me, Mr. Watkins.
No questions at this time.
Dr. Yep, any questions?
No questions, thank you.
Okay, one last opportunity. Do any of the panel members have any questions? Okay, hearing none, this concludes oral arguments in this matter. The record's closed, the matter is submitted, and we are off the record.